2012 and has represented the union and the state on various important issues of national importance and the state importance. Uh, Despite coming from the family of legal tizen, we all know that Sir is very humble and is always courteous to all the juniors and seniors. And I must tell you all one thing that uh, Luthra sir is very generous for all the younger generation, and he always offer his help, no matter how busy Luthra sir is. Luthra sir is inside the courtroom, and especially when there is a junior counsel who is on the opposite side. Sir is very courteous and many a time offer his helping hand as well while actually arguing the matter. Luthra sir is also a member of the Delhi State Legal Service Authority and also vice president of the Indian Criminal Justice Society, and also sir actually sits on the advisory board of the important journals like Delhi Law Times and Delhi Reported Judgments. While having so flourishing practice, I must tell you all that Luthra sir also devote a lot of time for pro bono work as well. Luthra is also having a very great passion for teaching, and therefore he is also a visiting professor in a very well-renowned Northumberland University in Newcastle, United Kingdom, and also an honorary professor in the MIT University, Noida. I must tell you all that when we are finalizing the list of the senior advocates who are supposed to deliver this lecture series, unanimously we all chosen Luthra sir's name because in some way or the other, we all have benefited from sir. Many of us as a student, when we were in college, and whenever Luthra sir used to visit our college for actually delivering a guest lecture or something, and so I am very grateful to you, sir, because you always have a very busy schedule, and you have actually taken out time during the summer vacation to actually offer this to deliver this lecture. So over to you, sir.
Thank you, Kaustav sir. Good morning to all, and good morning to our senior advocate Luthra sir. Welcome to the 5th lecture series of SCAORA. And today we are honored to have Luthra sir, and he is going to deliver a lecture on leading cases, which is scheduled for 15th of this June. And any queries regarding this lecture aspirants can put on chat box, and it can be dealt later. Now I request Luthra sir to please start the lecture, sir. Thank you so much.
Thank you so much, everyone. My friends, Vipin, Nikhil, Amit, Asta, Kaustav, and thank you. So all of you, thank you. Kaustav, you're absolutely right. It's a warm welcome is the appropriate atmosphere for today's weather in Delhi. I'm told it's very hot. Fortunately, I happen to be out, but it's warm everywhere in the country. I must share with you that I am an examiner, though I have not set the paper this year, so I'm safe. I can let you know. I've also been asked by Asta to do the criminal law part of the lecture, the cases, not all. Am I right, Asta? Right. If you want me to do the others, I'll be happy to do them. Not a problem. But I really want you guys to understand one thing, that when we look at leading cases, and I've had a passion with this, because I worked very hard to streamline this. I had a problem with this when I first started doing leading cases. The difficulty we were facing was that we had cases which had been overruled or otherwise distinguished, and therefore there was a need to upgrade the system. So I worked hard. It took me 2-3 years to upgrade the system. As you know, this year we're also starting a new mechanism, which is to have electronic computers for you to write your papers. But before I start on the cases for today, there is something I want to share to my young friends here, which is important, I believe, for all of you who are taking this lecture. And that's the first thing. How are you going to approach the paper? Leading cases is a very important subject. But to approach the paper, one approach is, if you're asked a question, answer simply on the question and only answer about the case at hand. As an examiner, and since I was an examiner about 4 or 5 years ago, when I started setting the papers 5 years ago, we started having composite questions. That is to say, illustratively, you put down in my course Rupa Ashok Hora or Antulay. So if Antulay was asked, only Antulay was asked. But that's, as an examiner, please understand, though this is leading cases, if you want those extra marks or if you want your answer to shine, you must write not just about Antulay. If you're asked a question about Antulay and Curative, but you must also talk about Antulay, Rupa Ashok Hora, and then how it has been applied, what is the test, and how the rules on Curative came out of it. Now, this is what, as an examiner, is going to get you the extra marks. Strictly, you may say, well, this is not leading cases, but the point is, we as examiners require you to think. So it's not, in leading cases, it's not just a summary of the case you have to give, it's the application of the case also and how it has been dealt with. And those are the places where you get more than your pass marks because you've gone beyond what people would have done. So that's the first introduction I wanted to give to you. Now, I have a series of, I've been given, today my task was to deal with a few cases. So I'm going to begin first with the leading case of D.K. Basu. A little history. There's D.K. Basu, I believe, was a judge. He talked about certain cases of custody torture. Matter was taken as a PIL before the Honorable Supreme Court. And the issue that was dealt with, and Dr. Abhishek Manu Singhvi was the amicus, the issues that were dealt with in some detail were about the right to life of vis-a-vis the right to the state to control your liberty, being an accused person. So that was a very important thing. Now, if you look at D.K. Basu, and I'll tell you my understanding and analysis of it, what does D.K. Basu do? Actually, not very much. D.K. Basu does, number one, it talks about, it gives guidelines on what to arrest, name tags, police officer carrying out the arrest of the arrestee, person who's detained, right to inform a friend, right to inform a relative, a right to be informed of grounds of arrest, place of arrest, custody must be informed by a police officer, and of course, inspection memo provided if there are any injuries on the body, the memo of arrest and the FIR to be provided sent to the judicial magistrate, Ilaka magistrate, and person is to be examined every 48 hours, may meet his lawyer. Now, most important, category 10 was, point 10 was, arrestee may be permitted to meet his lawyer during interrogation, though not throughout the interrogation. A police control room should be provided at district and state headquarters where information regarding the arrest and place of custody shall be communicated by the officer causing the arrest within 12 hours of effecting the arrest, and the police control room should be displayed on a conspicuous notice board. Let us say a person is arrested. You don't know where the person is. How do you find that individual? You find that individual by going to, you can go to the police control room and there is to be a record of all such persons arrested. But that's one part of the matter. What also, if I would like you to see, is when you read this judgment, please consider two things. That D.K. Basu's judgment led to some fascinating amendments in 2005 to the CRPC. And those now have, in fact, incorporated some of the D.K. Basu principles. So those are an important element. Also, what are the consequences? There can be disciplinary action in the case of a breach or even otherwise. So that is also important because the principle used in this case was ubi jus, ubi remedium. So, if there is a cause, there must be a remedy. Now, what is the remedy? Let's say a person breaches this. The CRPC does not provide anything. The penal code provides little succor. If, let's say, you're wrongfully arrested, you file a complaint, the process takes forever, and a person who has suffered a wrongful arrest would not want to do that. Different matter. Today, we have two judgments, Pankaj Bansal and the recent UAP judgment by where they've actually quashed the arrest as well. In one case, for failure to give grounds of arrest, Justice Sanjay Kumar quashed it. Subsequently, Justice Bela Trivedi's bench has taken a view that it is mandatory to be supplied grounds of arrest, but that should not result in a breach of in a quashment of the remand. But that's a separate issue. As I said, I was just giving you a little flavor of the matter. So an analysis of this case must be accompanied by an understanding of Nandini Satpathy and the statutory amendments that follow. That's what really makes an answer shine. But there's one important thing I want to tell you. When you look at Nandini Satpathy, there was a very crucial line which said, a lawyer can be present throughout interrogation during sight but not hearing. That is to say, the lawyer cannot interfere with the investigation. The lawyer cannot come and tutor you, but the lawyer can see that you are not physically abused. D.K. Basu actually dilutes that position. Could it? Nandini Satpathy, if you recall, was 3 judges, D.K. Basu was 2 judges, but the reality is that position stands diluted. Secondly, the safeguards in D.K. Basu do not only apply to the police, it applies to everybody. So please look at D.K. Basu in a composite fashion, as I have tried to guide you. I am fortunately not your paper setter, so I don't know what's going to be done, but it's something you must consider from this perspective, as in a larger perspective, to have a better answer. Now, the second case is the case of Selvi versus State of Karnataka. Selvi is an important case. The issue that came up was one of the cases which talks of the right to privacy in Article 20. Now, why was this? There is a point where a lot of tests such as polygraph, lie detecting, narco analysis, brain activation, etc., these are all being used now by investigating agencies. What is the scientific sanctity of these tests was one very important thing that came up. Also, if you are asking a person under who has been put to, let us say, an injection which is like a truth serum, and you are asking the person to speak the truth based on set responses, is that not a breach of Article 20? Thirdly, or measuring the responses when set questions are put, would that not constitute a breach of Article 20? These were and other myriad issues were the ones dealt with in Selvi. And what is important for you to see is that the Supreme Court held that all of these tests, if conducted involuntarily, are breaching the right against self-incrimination, Article 20. And it deals with Article 20 in a very nuanced fashion and explains how it is required to protect accused, to protect witnesses during investigation. Also, these results cannot be taken as the gospel truth. These are investigative tools at the highest, and the scientific validity of some of these tests is a matter which is subject to debate. At least it was so said in Selvi's case in 2010. I believe it is still a subject of debate. And thirdly, don't forget, please look at Section 45 of the Evidence Act. 45 says any opinion of an expert is a weak piece of evidence. At the highest, these are only opinions of experts, nothing more, nothing less. So please look at it in this composite fashion. The results from the tests, since it has been found that they appear to be testimonial, they can't be of a material evidence. And also the fact, and this is important for us to keep in mind, that nobody can be forced to take these tests. But if you as an accused while in custody volunteer, you can be asked to do the test. If, of course, the police want somebody to take a test, they will have to move the jurisdictional magistrate, and subject to the safeguards, it can be done. I must also point out that the view in this on privacy has been upheld in Puttaswamy. So you may also want to link this to the Puttaswamy principle. So this is judgment number 2. Now let us come to Antulay's case. I wish I had I had all of you before me, so I could orally also interact with you, but I understand with so many people, and I'm sure there are a number of you, it'll become a problem. Just give me a second. I think my... Sorry, I thought my office was calling me to let me know if there's a problem with the connection. which sometimes can happen. Now, Antulay is a very important case because Antulay is a case where we were dealing with a former Chief Minister of Maharashtra against whom certain allegations were made. Mr. Jetmlani was opposing him and he was seeking to prosecute him. And in this entire case, the Supreme Court had passed an order way back, I think 84 or 84, to say that the special judge under the 1947 Prevention of Corruption Act should not try the case, but the High Court should try the case. Now, this was done judicially. I must also point out it was done later again in the 2G case, but that's a separate issue. That aspect was upheld. Now, that aspect has not gone, but the point is the Supreme Court had earlier transferred the case from the special judge to the High Court. And what was important was whether such an order could be legally done. Petition was filed. The leading opinion was by Justice Mukherjee for himself and Justice Ojha and Natarajan. Justice Ranganath Mishra concurs with Justice Mukherjee, partly, differs on some parts. Justice Ray concurs with both. Justice Ojha also gives a short opinion, dissenting on Mukherjee with certain aspects. Venkatacharya, Judge, later Chief Justice, dissented with the majority, but did not upset the final directions in the matrix of the case. Now, what did the court do? In a 32, the court sought to recall its earlier order. Now, there's a legitimate question. Can it be done? The fact is, the court held that under 7(1) of the Criminal Law Amendment Act, the jurisdiction was on the special judge to try an offense under Section 6(1) of the 1952 Act. And that jurisdiction overrode the 52 Act, but did not vest any power in the High Court to try the case itself. Very important thing. Secondly, the Supreme Court to transfer the, Secondly, the power of the Supreme Court to transfer cases not wider than 407. And the decision earlier was per incuriam because it was contrary to the statute, which said the special judge and the special judge alone will try. Under the CRPC 1926, if you see, the High Court is a court which can try a criminal case, but that power has to be conferred by statute. It can't be assumed. So therefore, the question was, should this earlier order be allowed to stand? Could it be interfered with? And the Supreme Court took a view that an order which is per incuriam, contrary to either a binding precedent or to a statute, is in violation of constitutional limitations, derogation of natural justice, and can be corrected by the court on the principle ex deficitio justitiae. That is to say, the act of a court should not prejudice anyone. And therefore, the court acted in order to see that the fundamental rights which seem to be were infringed should not continue to be infringed. Ranganathan, of course, says, look, I can't lay down the principle as to what are the that come in the principle ex deficitio justitiae, but the power is traced to 142 and most important, the inherent jurisdiction of the Supreme Court. Remember, the Supreme Court and High Court are courts of record. So the inherent jurisdiction of the Supreme Court existed, and Ranganath's this line becomes very important. Justice Venkatacharya disagrees. He says, look, you can't correct an order in writ or on suo motu power. You have to do it by virtue of review. Article 37 exists. Only case where you have an exception is if it's a case of failure of natural justice, judgment obtained by fraud, etc. In such cases, you can do so, otherwise no more. Now, a little more. Mukherjee holds that the power review can be exercised by the court suo motu without asking for a formal review, even under 32 or 136. Ranganath Mishra, and Venkatacharya dissent from this view. So Ranganath Mishra, Ray, and Venkatacharya forms the majority opinion on the point that a writ does not lie against the order passed by the Supreme Court. So it's a very crucial point which you must consider. Now, I would like you, and look, I'm broadly giving you these principles from my memory, partly from my notes, but scrutinize the interpretation because there's a practice very often that we will only look at the majority. Let me tell you, as an examiner, sometimes we will look at the minority also. Now, and we will expect you to respond to the minority. Of course, as I said, I don't know what is in the exam. Now, this was Antulay's case. After Antulay, obviously, people tried the same game once or twice. And then finally, in Rupa Ashok Hora, an issue was framed whether an aggrieved person is entitled to relief against a final judgment of the Supreme Court after dismissal of review petition, either under Article 32 or otherwise. Now, I'm going to pause here. I do hope you also look at Naresh Mirajkar's case. Mirajkar said a writ will not lie against a judicial order. So if Mirajkar says writ will not lie, yet at the same time, the Supreme Court interferes in Antulay's case, and then you have Rupa Ashok Hora, and Rupa Ashok Hora of 2002 carves out a new jurisdiction. It carves out what is later curative jurisdiction in Chapter 48 of the Supreme Court Rules of 2013. Earlier, we didn't have the curative jurisdiction. It was under Rupa Ashok Hora's case, but thereafter, it has now been framed as a rule of the Supreme Court, and it's important for us to analyze it. Therefore, a question on Antulay or Hura will also have to be linked to the rules and the amendment made to the rules if the answer is to be an appropriate answer. Of course, it depends on the nature of question asked. But if it is asked about the evolution of curative jurisdiction, then you must take it step by step and also perhaps touch upon Mirajkar. And that's something which, as a background, you should have. I believe Mirajkar may no longer be part of your case syllabus, but it's an important decision to see in any case. So, what does Rupa Ashok Hora say? They say high courts can't issue writs to another high court. One bench cannot issue a writ to a different bench of the same high court. Much less can the high court be invoked to seek issuance of a writ to the Supreme Court. So that's part one. Judgments of orders of the high courts can be corrected by the Supreme Court in appellate or special leave petition jurisdiction, right? 132 to 134 and 136. High courts are not inferior courts in the constitutional scheme. They are constitutional courts. Therefore, SC should not issue a writ under Article 32. You often will see in court that the Supreme Court, while passing an order, will say, we can't direct the High Court, we'll request the High Court to do this. They may give a direction to a trial court. They will always request the High Court because most judges, and thankfully so, are mindful of the fact that there has to be, the hierarchy of courts has to be respected. Now, this principle is important. Further, the additional principle was a smaller bench, not a larger bench of SC, can issue a writ of 32 to another bench. And this can be invoked only for the purpose of enforcing fundamental rights in Part 3. No judicial order passed by a superior court can be said to violate fundamental rights. That's the Mirajkar principle. Therefore, with all these principles together, Article 32 will not lie against judicial orders. Of course, in the context of transfer petitions in the erstwhile state of Jammu and Kashmir, 32 was given recourse to, and there's a constitution bench judgment, separate story for a separate day. Now, the Supreme Court now looks at this point in Hura's case and says, look, Antulay, but is that correct? What power that can be exercised? And they lay down three principles. One, review has to be exercised, SLP or appeal, review, all of that done. And after review, it is not a second review. It is a curative jurisdiction, inherent powers to be exercised, A, violation of principles of natural justice, party is not heard, or yes, let us say the judge has an interest, or one of the judges has an interest in the matter. So these are two fundamental grounds, but they also say any other ground that may be permissible. Now, this any other ground becomes a question that's said in another place, but it's an important decision. I want you to see, of course, there are safeguards in place, senior advocate to give a certificate, AOR to give a certificate, all that exercise is to be done. So the procedural part in Hura's case, tied to the 2013 rules, are part of a composite understanding of the curative jurisdiction. Now let me come to the fifth decision in my case study, and I can see this is taking longer time, Asta, than I thought it would, but it is my duty to justice by my young friend, my understanding. All of you know that there is a thing called the Delhi Special Police Establishment Act. Now, what is the Delhi Special Police Establishment Act? The Delhi Special Police Establishment is the body, is actually the CBI. Later on, it got the name CBI, akin to FBI. Perhaps it was sort of given some importance. On a separate note, the Guwahati High Court said that the CBI has no statutory or legal existence. It is functioning illegally, as a result of which the Supreme Court stayed that out of the Guwahati High Court Division Bench headed by Justice Ansari. And today I must share with my young friends that CBI is operating under a stay order. But let's leave that for a moment. Let us, for the sake of this conversation, assume that the 5 judges bench judgment in State of Bengal versus Committee for the Protection of Democratic Rights, 2010, 3 SCC 571, deals with the Delhi Special Police Establishment Act. Now, policing, as you know, under the 7th schedule is a state subject. If it is part of the state list, can you have a centralized police agency? The only exception is in subjects such as NDPS, ED, NDPS being under treaty obligations, PMLA being treaty obligations, and CD as all India jurisdiction. Income tax, GST, of course, now there's a new mechanism. In all such cases, you have specialized entries which protect it, but policing per se is on the state list. Therefore, the Delhi Special Police Establishment, or the CBI, can only investigate a railway area or a union territory in a state with the consent of the state government. So the state government's consent is crucial, and that is the reason you would have seen that states these days, often, especially opposition-ruled states, in any government opposition in terms of the center, irrespective of who is the ruling dispensation of the center, they will often recall and withdraw the power of the CBI by revoking the notifications under the DSP Act. So there has to be a notification by the state government empowering the CBI to investigate within its domain and territory. There also has to be a confirmation by the central government. So there's a composite mechanism, Section 3, 5, and 6 of the DSP Act, which you may want to see while reading the judgment of State of West Bengal versus Committee for the Protection of Democratic Rights. Now, what does it say really? What it does is it says Article 226 is applied by the High Court to give a direction to CBI to investigate. The challenge is to say, without the consent of Section 6 of the DSP Act, keeping in view entry 2 of list 2 and entry 2A of entry 80 of list 1, no such agency can work within any state. Now, this matter became a matter of some deep concern. So the Supreme Court deals with it and puts in 2 principles, very important principles. I think it is para 68, if I'm not mistaken, of the judgment. Now, the 2 principles are this. Every individual has the right to a free and fair investigation. Victims have the right to a free and fair investigation. A. B. The High Court under 226 can direct CBI to investigate a cognizable offense. C. The High Court, while exercising power under 226, is not restrained by the DSP Act because it's an exercise of power of extraordinary jurisdiction, and being the High Court, the consent of the state is not necessary and there will be no impingement of the federal principle. So therefore, whether under 32 or 226, courts can give directions to CBI to investigate in a crime in a state, and they do not require the consent of the state government. However, and this is very important for you to consider, there are self-imposed limitations on exercise of this power. It is not to be done across the board. The court has very delicately determined 3 principles: the fundamental rights in Part 3 being inherent, the provisions of the law, DSP Act, the effect of the rights guaranteed under Part 3, and how they are important to ensure the basic structure of the Constitution, and how, while federalism is an important principle, that will not hold back the exercise of power under 226. So this is the judgment in the 2010 Constitution Bench judgment. Now let me come to another provision, which is 438 anticipatory bail. All of you have read 438 anticipatory bail, I'm sure. Though Justice Trivedi last week was teasing both Mr. Rodgi and me to say that the last court for bail was the High Court. But the fact is today, there is great amount of exercise of power in the context of bail by the Honorable Supreme Court, whether for bail or cancellation of bail or quashment of bail orders. Either which way, either these three powers are exercised. Sometimes we even come up for modification of conditions of bail which are not granted by the courts below. But Sushila Agarwal, the 2025 judge bench decision is important. But let's pause here. Can we talk about Sushila Agarwal without considering Section 438 of the CRPC? Can we consider Sushila Agarwal in 438 without considering the 41st report of the Law Commission, which for the first time in India introduces this unique provision of anticipatory bail? Secondly, the word anticipatory bail is not used. The word used in the provision is bail in the event of arrest. Now, this is a provision which is rather important, and you may want to consider it from 2 points of view. One, it's a remedy, it's not a right. Therefore, when 438 was brought in 73 by the 74 Code under this 1973 CRPC, brought in first, I think it was Act 1 of 74, 438 was introduced, anticipatory bail was introduced. In 76, if I recall correctly, the state of UP, concerned about gangsters, there was a lot of dacoity at that time, and they had seen this belt amongst others. The UP had done away with anticipatory bail, saying it does not apply. This issue of anticipatory bail being removed from UP was upheld by the judgment of the Constitution Bench in Kartar Singh's case, which was also a judgment on Tada, because Tada did not have anticipatory bail, but Kartar Singh upholds the removal of anticipatory bail from the state of UP. This continued in the state of Uttarakhand, which was the successor state of the state of UP after the two states were carved out. And later, first UP revoked it and brought back anticipatory bail. Thereafter, Uttarakhand did it firstly by judicial exercise, and later it was done legislatively also. So anticipatory bail as on today applies across the country. Now, the question here was in Sushila Agarwal that the classic judgment in this, the locus classicus, is a judgment called Gurbakh Singh Sibia, AR 90, AR 1980, Supreme Court 1632. I'm giving you the AR citation. You can use the SCC citation. I must also tell you, nobody objects to the, as far as I know, in the exam, to using SCC citations or AR citations or SCR citations. But I mean, the practice is now increasingly to use SCC only in court. And now, of course, the Honorable Chief Justice has brought in the new system of giving judgment references. When that becomes in vogue, I think SCC will also become a little outmoded. But today, SCC is preferred. But merely because you give an AIR or SCR citation, you will not lose marks provided the citation is correct. It should not be a situation that you give an imaginary citation, as sometimes people tend to do in exams. Now, I'm going to take you back to CBI. Any understanding of Sushila Agarwal has to be predicated on an understanding of CBI. In Sushila Agarwal, there are two opinions. One is Justice Shah's opinion, and the other is Justice Bhatt's opinion. Justice Bhatt's opinion is more composite, but they lay down a number of principles thereafter, which are the composite principles laid down by the bench. Now, what does Sushila Agarwal say? It is really a regurgitation and refinement or attempt to refine the principle in CBI's case. CBI is actually, as I would say, locus classical. It's a beautifully written, clear judgment. And any understanding of anticipatory bail must be predicated on Gurbakh Singh CBI. So please read CBI as well. When you read CBI, you will realize that from 1980 till 2020, till the Sushila Agarwal judgment comes, what had been happening was that there were a lot of views, especially post-liberalization, to restrict anticipatory bail. There were restrictions being read in the context of economic offenses. That's a 97 judgment, state of CBI versus Anil Sharma. Then there is Salahuddin Ahmed. Then there is KL Verma, and amongst others. So all of these kept restricting them. These culminated in a two-judge bench decision called Maitre's case, Siddhalinga Maitre's case, Siddharam Satlinga Maitre, which is, I believe, 2011, 1 SCC 694. Now, this is a judgment which says, look, CBI has good law. All the judgments of 2 judges and 3 judges that have come, all are incorrect. They lay down bad principles. CBI remains untrampled. But then the question was, could 2 judges in Maitre's case overrule all the 2 or 3 judges' larger bench decisions? Were they not making exactly the same error that had been made by those earlier judgments after CBI? So finally, a constitution bench of the Supreme Court was constituted, and they have laid down composite principles, and they have actually fine-tuned CBI. To my mind, some clarity needed, and some of the important findings are that economic offenses are not a class apart. Heinousness of the offense is to be measured based on the sentence of the offense, not the values of the crime involved. So how much is the maximum sentence that can be imposed? Whether murder cases should be excluded, no, life sentence cases not excluded, but these are rarely given. So I would commend that both my friends read both the judgments, and after that read the principles that are culled out. But please consider the 2005 amendment also made to the provision of section 438, which is also important while considering this issue. Now let us come to Lalita Kumari. 2014, 2 SCC, page 1. A constitution bench of the Supreme Court was made to sit down to see whether FIRs ought to be registered automatically or not in cognizable offenses. Now, we all know what a cognizable offense is. A cognizable offense, as defined in the CRPC, is where a police officer can start an investigation without waiting for the consent of a magistrate. If it's non-cognizable, he has to go to the magistrate for 155(2). In a cognizable offense case, the police officer can start and go on straight away. Now, what is also important for your consideration, which I will point out to my young friends, is this, that Lalita Kumari took a long time coming because it was pending for a very long time. There was a reference made on this issue, and it had to consider that under the state police rules, for example, the UP Police Regulations 104, or the Punjab Police rules, which apply to Delhi, to Haryana, Punjab, Chandigarh, Himachal Pradesh, or the MP Police Regulations, all of these provide for a concept called an inquiry. In some places, the Commissioner of Police or the DG of Police issues what is known as standing orders or directions, or issues circulars which are binding based on the power conferred by the statute on the DGP of Police in terms of the state statute of the Indian Police Act of 1861, if I'm not mistaken. And those provisions allow you to carry out an inquiry. So on the one hand, police would often register and start inquiries and not register an FIR because they believe that these cases sounded questionable. But the contours of that jurisdiction were not defined because there was an interplay between state police rules and regulations and the CRPC. And the CRPC, as it read, meant that FIRs must be mandatorily registered. I had the privilege of appearing in this case. I think I'd appeared for either MP or Chhattisgarh, as I recall. But that's not the relevant part of this lecture. Now, what is important is the Supreme Court goes through this entire issue. It also deals with CBI. It deals with preliminary inquiries. It deals with the concept of when and how FIRs are to be registered. But more important, it says in para 120, when and how you can have inquiries. For example, if there's a very delayed, this crime is 2 years old, or it's a corruption case where you need to find out, people's careers can get destroyed, or a matrimonial matter where you know there are CAW cells, crime against women cells in almost all jurisdictions, or cheating cases, which are borderline, half civil, half criminal. So those also have to be seen. So when you see all of this exercise and you look at this entire area, there are cases where you will have to do an inquiry before proceeding further. Now, I must point out that there is a limitation that was put that any inquiry must be done within 7 and 15 days. There is a subsequent order, which you may want to locate, which clarified the position, and that said that that clarified the position and that increased the time for inquiry from up till 15 days to 6 weeks. And that is also reported in scale, as also I'm told in SCC. I must also point out, we must consider what is the scope of inquiry. One, not to verify whether the case is true or false, but to see if an offense is disclosed. Now, in medical negligence cases, post the judgment in Jacob Matthew, you know there has to be a medical expert's opinion. That's another case where preliminary inquiries are to be done, and they are to be done because till the police officer has an expert opinion, he ought not to register the FIR because it may just be the ipse dixit of a unhappy patient, a patient who may have lost either health or may have lost a family member, who comes out with anger, says the doctor has killed my patient, but because it is a medical negligence matter, it's a surgical table matter, it's a treatment matter, these issues have to be seen from the perspective of contemporary standards of medical training and medical science. Therefore, it became imperative to apply tests and hence preliminary inquiry to be done. There is also an interesting discussion on the interplay between the general diary, which is the diary which is maintained in the police station. I must point out at that stage when I was doing it, Justice B.S. Chauhan was on the bench, and 2 or 3 of the judges who were on the bench had never seen a general diary before. So he told me, he said, you'll have to show it to my brother and sister judges, Justice Ranjana Desai, of course, had seen it. I had to call for it from Tilak Raj police station in lunchtime and show it to the judges at 2 p.m. to see how in Delhi, North India, at least the four of the states, how the general diary is maintained. There are, of course, similar provisions and some variations which are state-wise. So now I will pause here for a moment. And before I come to the next section, just give me 1 minute. I'm just arranging my papers. Okay. Sharad Birdi Chand Sarda. We all know that in a criminal case, especially in a hurt case, there are 2 principles which are very important. You may have a direct evidence case where there are eyewitnesses, that is to say witnesses who depose about what they have seen, the crime being committed. And then you have circumstantial evidence cases. Now, circumstantial evidence cases become challenging because there, how do you determine, let us say a person is seen last in the company of my friend Vipin Nair and next day goes missing. Now, if that is the case, it's a concept of last seen together. Now, here, nobody's seen the crime being committed, but a few days later, a dead body is found with a person who's been proceeded with with circumstantial evidence. Now, in such cases, the nature of scrutiny had to be defined by law. So what the principle that we have taken is that the chain of circumstantial evidence must be complete. That is to say, if there are 5 circumstances, they must be connected in such a manner that the only and only hypothesis is that the crime has been committed by the offender who is under arrest or under prosecution. No other hypothesis should be possible. And therefore, it must be of great certainty. And of course, even the 313 statement, which you all know is the statement in defense, not an oath by an accused, to explain the circumstances against him. If there is a false denial, that is a circumstance can be used against the person in a circumstantial evidence case. So the principles laid down in this case is A, circumstances from which the conclusion of guilt is to be drawn should be fully established. B, facts so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, no other explanation should be possible, no other hypothesis that the accused is not guilty. 3, circumstances should be of a conclusive nature and tendency should be vague circumstances. 4, they should exclude every other possible hypothesis except the one to be proved, that is of the guilt of the and if the chain of evidence must be complete so that no reasonable ground is left to come to a conclusion other than the guilt of the accused, and that in all human probability, the act must have been done by the accused and by no other. So these are the broad principles, the five golden principles, which are called also the panchsheel of the proof of a case based on circumstantial evidence. Now, I must tell you, the additional principle is, does the Supreme Court interfere in cases of concurrent jurisdiction on facts? Orderly, no. But the court can always be told that the circumstances have not been appreciated by the High Court correctly, or all the circumstances have not been appreciated, or the exculpatory circumstances are not being appreciated, and the exculpatory circumstances override the inculpatory circumstance. And that becomes, my young friends, or my friends, I should say, very, very crucial for understanding the principle. And please see, Sarad Birdhichand Sarda is the law of the land. It has been followed from time to time, consistently, sometimes sought to be fine-tuned, but it's a classical decision, which I would really recommend. The late Mr. Jethmalani, legend that he was, argued the matter, and the principles are laid down with his help. Now let us come to a slightly change in topic. Navtej Singh Johar, 2018 10 SCC, page 1. Now, what was Navtej Singh Johar dealing with? Navtej Singh Johar was on the principle that 377 IPC is ultra vires the Constitution, ultra vires the fundamental rights, the right to sexual autonomy, the right to sexuality, and the right to choose a sexual partner of your own choice. Now, this became a very important decision because I must tell you, earlier the Delhi High Court had read down 377, a bench of Chief Justice A.P. Shah, as he then was, and Justice Muralidhar, when he's of course now practicing amongst us, but he's back to practicing amongst us. But when he was in the Delhi High Court, sitting in the Chief Justice along with the Chief Justice. So they took a view in a case called Naz Foundation, and Naz Foundation then gets challenged before the Supreme Court, and the Supreme Court takes a view in a decision called Suresh Kumar Kaushal versus Naz Foundation. If I recall correctly, it was Justice Singhvi's bench, and I don't recall who the second judge was, possibly Justice Ganguly, but that's the view it was taken. At that occasion, I must say, I had the privilege of appearing for teachers who had gay students and who were concerned about the impact of their students being persecuted while expressing their own individual rights and the right to their own sexuality, autonomy, and freedom. Now, this is an important decision because the Indian Penal Code is a law in 34 countries, even today. Even the BNS, which is going to be the new version of the Penal Code, is really a reframing of the same language and same principles, some minor tweaking here or there, but it's fundamentally the same law. And 377 was retained in India for a long time. It was rarely used, and especially in the context of consensual sexual relations between two persons of the same gender. The issue was really whether such a thing should be punishable in law. Now, force was a different matter, but if it was consent, should it be punishable? Should the police be looking into people's homes or bedrooms? That was the principle. It was a job perhaps for the legislature to do, but it came to court. And in the first round, Suresh Kumar Kaushal's case, the Supreme Court upheld it, saying it's a minuscule fraction of the population, and existence of 377, really doesn't impact society at large. Now, 377 was therefore upheld. There was a review pending. Meanwhile, a substantive petition came to be filed which is before the Constitution Amendment under 32, which was Navtej Singh Johar and others. And in those petitions, the court held the following principles. One, and I'm just going to broadly give you the principles. Constitutional morality embraces within its sphere several virtues, including inclusive society. Societal morality cannot be used to violate fundamental rights of even a single individual, as the foundation of constitutional morality rests upon the recognition of diversity that pervades society. B, a right to live with dignity is recognized as a human right on international fronts. Court must strive to protect the dignity of every individual. Sexual orientation is a biological phenomenon which is natural and inherent in an individual and is controlled by neurological and biological factors. Suresh Kumar Kaushal, 2 judges, is overruled, saying 377 abridges fundamental rights of individuals. T 377 and 377 was considered, and they talked about the aspect that you cannot criminalize voluntary intercourse between homosexuals, heterosexuals, bisexuals, transgenders, etc., of a kind which is alleged to be, is consensual. And 377 was kept separate. 377 was struck down, and the court said it's violated with the right to dignity and the right to privacy, and cannot be sustained on 14 and 19, and found to be unreasonable as well. There are other aspects in the judgment, but I must point out that if a man or a woman engages in an activity of that nature with an animal or with the that would continue to be a criminal offense. What is taken out is really the consensual intercourse and nothing else. And that is very important, because they said it doesn't harm anyone. In a private case, there's no impact on public decency or morality. Please read the 5 judges bench decision. It's an important decision. Then let us come to my young friend Joseph Schein. Now, why is Joseph Schein an important decision? Joseph Schein is a decision which deals with Section 497. Now, this was really the provision which dealt with bigamy in a sense, and they said, look, how can you adultery rather? I'm sorry, and how can you treat this as a prosecutable offense? So, in a Constitution bench decision dealing with the concept of manifest arbitrariness as well, which is a very important principle, which I would commend. You read, and you also read the other judgment on manifest arbitrariness. The court said it is an archaic provision which really cannot be sustained in today's society, because it's an infringement on the woman's right to life and personal liberty by subverting equality, applying penal sections to a gender-based approach in the relationship between man and women, and therefore aspect of connivance or consent on the husband translated to subordination of a woman. And adultery may be a civil wrong. You can get divorce on that, but you cannot criminalize it. And criminal offenses are again offenses against society. Adultery is a personal matter. It is not an offense against society, and people should be allowed to make their own decisions. And that was the gist of the matter. Important decision, Constitution bench, please consider it. Now I'm going to go back a little to an old decision called Vishaka. Asta ji, how much time more do I have?
Sir, as much time that you want to take, sir.
No, I mean,
Sir, I'm sure all of us are very...
No, I hope
No, sir, I'm
too bored, because I have I think Asta, Ramachandra Rao, Sriharan, and Mukesh. Yeah, that's another 5. So I'll do that. I wanted to just take them to the gist of it, so that I'm not giving them a gist, because I'm not rewriting the papers for them, but at the same time, they need to get a
sir.
paper.
Sir, I'm sure they're loving it, sir. And anything else that you want to do over and above the list also, sir, please feel free, sir. It was only so because we didn't want to burden the seniors with all the 64 cases at once, sir. But it's been a wonderful session hearing you, sir. So please go ahead. The time is not a constraint at all.
I'm never burdened. It's a pleasure to exchange my thoughts. And I'm sure when the questions come from the audience, I will be learning a lot more, because I have to revisit the judgments and learn more. So I'll just take a little more time. I plan to finish
Please,
this,
sir.
but मुझे थोड़ा समय लगेगा, 15 मिनट और.
No problem, sir. Please.
ठीक है. Now let me come to Vishakha. Vishakha versus State of Rajasthan, 97 Supreme Court, 96-97 Supreme Court is very important. You know, the issue was that there was sexual harassment in the workplace, and that's a matter which is unfortunately permeated society, and that's part of the inequality, social inequality that pervades most societies. The distinction that societies consciously and unconsciously draw between men and women, though frankly it should not be so. But the issue was this, that there was no legislation on the subject, and therefore in Vishakha's case, people reached out to international convention and asked the court to legislate. Now, Vishakha is an interesting case where the court has actually legislated using the ground that, look, there is no legislation. Until government legislates, we must bring in some principles. So using the power under 32, talking of the principle of gender equality, talking of the principle of right to dignity, for protection from sexual harassment, being a universally recognized human right, the court has gone forth and given certain guidelines, and those guidelines are very important. Actually, it was a very important thing that had to be done, but keep one thing in mind. It begs the question whether courts can legislate, and I must tell you, courts are still continuing to legislate in a judgment called Ritesh Sinha, where voice sampling has been allowed to be taken. Courts are again legislating. Justice Gogoi in a 3-judge bench combination gave directions. But if Article 21 is procedure established by law, can you have procedure established by a judge and call it law for the purpose of 21? Because what are the remedies against a wrongful application of the law? So these are issues which are a larger public debate, which we'll have to see. And the reason I'm raising these issues is that while in Vishakha's case, the guidelines culminated into the 2013 Prevention of Sexual Harassment at Women at Workplace, Prevention, Prohibition and Redressal Act, the fact remains that there are other places where courts legislate, and the legitimacy of that matter becomes very crucial. The legitimacy of such court-ordered directions and mandated guidelines and timelines were also considered in a 7-judge bench of P. Ramachandra versus State of Karnataka. Now, why is Ramachandra important? I must share that with you. In 96 and 99, courts finding that people were locked up in jails, not getting bail, remaining in custody for long, trials were not proceeding, decided to pass the Supreme Court in 2 combinations in 96 and 99, pass certain directions to say trials will be done in X period. If bails are not, if person is in custody, bail will be granted. So they started giving time periods, and if evidence is not complete in a certain part, the trial will fail. Now that was a judicial exercise in a legislative domain. And the context came partly in the issue of delay in trials and delay in proceedings. But this raised a larger issue which lands up in a 7-judge bench decision 2002-4 SCC 578. Broadly, 2 principles related. It's a very short, I think about 10 or 12 pages judgment. You must read it meticulously. It's a short, succinct, and clear decision. There is also the 7th judge, I forget who, I forget the name, just give me a minute. He had dissented. You must also read the dissent. Now, what is this decision about? The decision says, firstly, Antulay in 1992 had said, and not the 88 Antulay I was talking about, the 92 Antulay, said that their delay in trials may be a ground to be considered, but it is not an absolute ground, and it has to be seen on a case-by-case basis. Whose delay is it? Counsel's delay? Accused absence, interlocutory proceedings, systemic delays. How do you determine what delay, and can you provide strict timelines? The answer was no. It has to be seen on a case-by-case basis, keeping in view that in our country, we have a poor judge versus population, and judge versus population versus cases issued ratio. So the decisions in common cause 196, common cause 299, and there was, I think, R.D. Upadhyay. All these were set aside, and the court said prescribing periods of limitation, at the end of which trial court would be obligated to terminate proceedings and necessarily acquit or discharge accused, and making such directions applicable to all cases and for future amounts to legislation cannot be done by judicial directives and is within the area of judicial law lawmaking power available to courts. You may interpret the law, but you cannot enact law. And that was how the court looked at a wholesome understanding of 32, 21, 114.1 and 142, and saying that we can interpret, we can fill in lacunae, we can deal with lacunae, we can fill in the gaps, but we cannot legislate. And this 7 judges' judgment holds the field. It also said that courts should use their power under 309, 311, 258 to make sure there are effective and fair trials and expeditious trials. Where trials are not expeditious for no fault of the accused, powers under 2482, 226, 227 can be exercised to even seek quashment of the proceedings, which was in line with the Antulay principle. Now let us come to the last 2 crucial decisions. Every decision here is very important, so therefore I'm taking a little time on this. Union of India versus Sriharan. I again had the privilege of being associated with this at the stage. So Sriharan and others were the people who were assassins of the late Prime Minister Shri Rajiv Gandhi. They were on death row. They asked for being let off. There was a judgment called Shatrughan Chauhan, where death penalties for many were quashed. And in Sriharan's case, this was the matter which was pending. It was taken up by Justice Sathasivam. When it was taken up, the day it was taken up, Justice Sathasivam hears the matter. He had to follow the earlier decision. He follows the earlier decision, Shatrughan Chauhan. Immediately, the state of Tamil Nadu, at that time, the AIDMK government immediately issued release orders because these people's death penalties were quashed and made to life. So they issued a release order. Next day, I and Shri Mohan Parasran had moved the Chief Justice. He stayed the release, then reheard the matter and referred certain issues. They are issues A to G to the Constitution bench to see. And I'm telling you the questions. Whether an imprisonment for life means till the end of a convict's life with no scope for remission. Whether a special category of sentence of death exceeding 14 years can be made, excluding remission. Which is the appropriate government? Can they grant remission under 432, 433 after pardon is exercised by President under 72 and Article 161 of the Governor? That is to say, if President has refused pardon, can the state government, can the appropriate government act? Who has primacy for matters in list 3 of 7 schedule, union or state under 432.7? Whether there are 2 appropriate governments under 432.7, 432.7. Whether appropriate government under 431 can exercise power suo motu, and whether procedure prescribed is mandatory or not. And does consultation in 435 means concurrence, or is it only consultation? The Supreme Court has laid down in a very detailed constitution bench decision, explained the contours of section 432 and 433, that the power vests with the government, either state or center, to be exercised by executive authorities, president or the governor. And of course, the nature of power of the president is explained, the nature of governor's power is explained, and the power under 432, 433 is restricted to suspension, remission, commutation, and no power restricting exercise of power under 432 and 433, even if presidential pardon has been refused. We always believe that presidential pardon is only meant for death sentence cases. That's not so. It can indeed be cases for lesser sentences, even where offense is punishable by life or lesser sentences. Then there were tests laid down for the appropriate government, which is very important because this test has been applied subsequently in the judgment of Bilkis Banu recently. by Justice Nagaratna and Justice Ujjal Bhuyan. I would suggest that when you read this, you also read up the Bilkis Banu judgment. It's a very well-written decision. I was on the losing side, but that happens to me quite often in any case. And I'm always happy to learn from cases which I lose because they teach me where I've gone wrong. Now, it also deals with, this judgment lays down a threefold test for determination of the appropriate government. Was the offense in relation to a law where the power of the state or the union is there? B, in cases covered by proviso under 73(1), which fall under IPC, covered under Schedule 7 and List 3, Entry 1, concurrent list, both center and state can pass the law. It should be exclusively within the competence of union. And which authority may bring about, where union is doing it. If state has brought in law, then state will have primacy, of course, in the context of remission if their law is already there. Now, these are broad principles, but you should read the judgment composite incomprehensively. It also says that power under 432(1) must be not suo motu, but on the application of the aggrieved person, the person in custody, and the procedures has to be followed comprehensively under 432(2) and no suo motu power. Also, that consultation with the central government, where state and central both have to act, must be concurrence and not just pure consultation. Now we come to the last decision of today. Mukesh versus State Nirbhaya, the Delhi rape case. Two judgments, the lead one by Chief Justice Deepak Mishra, and the second judgment is by Justice Bhanumati. Both very detailed, comprehensive decisions. I would suggest since it's a supplementary judgment by Justice Bhanumati, please do not ignore it. If you can glance through it, if you've not already read it. Now, this was a case which was partly circumstantial, partly actual evidence eyewitness, because the lady who was killed and was raped and injured, the young lady was accompanied by her friend who is an eyewitness to the occurrence. However, the lady doesn't die the same day. She's somehow in some terrible condition. She's brought to the hospital and she's shipped to Singapore, where she breathes her last. I was the special prosecutor in the Supreme Court for this case, and I was assisting the court when the death penalty was upheld. Of three of the four accused, one had died in jail. There was a juvenile who was tried separately. Contrary to popular perception, the juvenile was not the main offender. When you read the evidence, you'll find out, though Mr. Subramaniam Swamy had filed a petition at one point, which he fortunately was unsuccessful. That Subramaniam Swamy versus Raju, separate a matter which I had appeared in as SG. But this Mukesh versus State is a very important case because it lays down principles on dying declaration, para 177, DNA evidence, para 228, criminal conspiracy, paras 286, 288, 290, sentencing, para 33, 41, 346, 510, relies on Bachchan Singh versus State of Punjab, and deals with the rarest of rare cases. What is more important for your consideration is that Mukesh for the first time brings out a principle which is called society's cry for justice. In the context of a death penalty, the court read that if a crime is so heinous that from it, the judge, based on the evidence and based on the material and evidence, not newspapers, can perceive that society's right to an ordered world would require the imposition of the death penalty, the court can do it. The argument against us was, by the two amicus, that this is populism. The court struck down that argument and said that in assuming death penalty, apart from heinousness of the crime, the concept of society's cry for justice must be considered in imposition of the death penalty. So that's a very important decision. Justice Bhanumati, of course, talks about how society is to be changed because crimes against women have to be prevented, not just punished. So with that, thank you so very much. If there are any questions, I would be more than happy to answer them if they're sent to me.
Thank you, sir. Thank you for your valuable time. And sir, I don't think anybody has many questions because you have dealt so detailed cases. I don't think they have any issues regarding any cases. But we are really honored to have you for today's lecture, sir. And I'm sure that we all have benefited from today's lecture. And more aspirants might have also been benefited. And I wish all the aspirants a good luck for their exams. And I also thank our EC members, Nikhil sir, Bipin sir, and our Amit sir, and all the EC members, Astha ji, who has given their valuable time. Thank you so much, sir, for your lecture.
Thank you.
There's one small thing, if I just. Sir had mentioned about one case which was wherein Rupa Hura and Ashok Hura was interpreted. That I could find that question in the chat box.
Yeah, so there are a number of cases which have applied it subsequently. There'll be short judgments and orders, number of them. So when you just Google Rupa Ashok Hura, you'll find how curative has been applied. So please see it. And therefore, my point is, there are some, of course, are simple dismissal orders, but there are cases where it has been applied. And if I recall correctly, it was also applied in the case of Mr. Vanvati, and I had appeared as...
Was it Assam Brahmaputra or something, sir?
It was applied in case of that Punjab terrorist who had a mental health issue. So they're in curative jurisdiction, they applied and they reduced the death penalty, if I recall correctly. Just check that out. But there are a number of cases because 50 and 51, para 50 and 51 of Hura are to be seen. But I think there's a para 58 also. So please read Hura. If you read it in first blush, it creates two openings. But then if you read it, it talks about a third opening also. So it's a very important thing. But as I said, any answer must be provision, statute, and development of the law. That is how you'll get those extra marks. I mean, that's the best I can guide you without giving you more hints.
Thank you so much, sir. Sir, for taking out time, sir. It was indeed an honor, sir, as usual. Thank you so much, sir.
And so
thank you so much. It was thank you.
You're all very dear and old friends, so I'm glad you gave me the opportunity. It's so kind of you.
Thank you.
We are privileged, sir.
Thank you.